Good afternoon, everyone. My name is Tony Kronman with Owen Fiss and Asla Bali. I am one of the three co-directors of the Kamel Center for the Study of Islamic Law and Civilization at the Yale Law School, which has now been proudly underway for more than a decade. We've sponsored many remarkable talks. We've had many extraordinary speakers, but none, I think, more remarkable or extraordinary than our speaker this afternoon. Mohsen Kadivar is a professor of Islamic Studies in the Religious Studies Department at Duke University, where he teaches courses in Islamic law, theology, comparative religion, a whole host of subjects, and has written nearly countless articles and books on subjects touching on these matters from one direction or another. So I've just said that, and that's a lot, but it barely touches the surface of the life and career of this quite extraordinary human being. Professor Kadivar is a scholar. He's a writer. He's a teacher. He's also a cleric and a political hero, a courageous and determined spokesman for reform in his native Iran, now living in exile in this country, separated, as he was telling Owen and me a few minutes ago, from his family in the country, enduring extraordinary emotional and physical hardship out of a commitment, I would say a simple commitment, but it's the last thing that one should ever call simple, out of a commitment, a resolute commitment to principle and belief and human decency and the values of a responsible political society. So today we're going to hear a talk whose title it includes a great deal. We have Sharia, we've got Fiqh, we've got Islamic law, and joining them all we have possibility/impossibility as the joining tissue that connects the various elements. I'm more than curious to see how Professor Kadivar will put the elements together for us today. But most of all, I'm just flat out proud, as one of the co-directors of the Kamel Center, to welcome a man of such integrity and intelligence and scholarly virtue and practical political virtue to the podium today. So please join me in warmly welcoming Professor Kadivar to the Kamel Center, to the Yale Law School, and to our community. Professor Kadivar.
Assalamu alaikum. Greetings to everyone. Thank you so much for your kind words, Professor. So this is my pleasure and honor to be here for the second time at Yale. Is it okay?
You can be adjusted a little.
After a few minutes, it will be louder.
Can you put the Bible up? Yes.
Bismillah ar-Rahman ar-Rahim, in the name of God. And as Professor mentioned, the title of my presentation today is about Sharia, Fiqh, Islamic law, and possibility or impossibility of Islamic law. So this is a difficult, I think, topic I hope that I have something to tell you new, different from what you heard before. And I should thank the Kamel Center and also Yale Law School for this invitation. I wrote my presentation, and for the respect to the you and also for the time, I try to read it, and sometimes I explain what I wrote. While it's common to use these three terms, Sharia, Fiqh, it was said Islamic jurisprudence, also a little bit doubtful about this translation, and Islamic law as synonyms. My first point is that although they are interrelated, but they are different. They are not the same. Sharia has been introduced in the Quran. Fiqh is available in so many books that are written since 2nd century of Hijrah or 8th century AD. And so-called Islamic law is a term that has been used since the 18th, 19th century. And its possibility is the question of this presentation. Muslims or Muslim scholars have used Sharia ruling interchangeably with Fiqh ruling in different legal schools for more than thousands of years. Do we mean by Islamic law codification of these rulings, such as Al-Majalla in late Ottoman? Or does Islamic law means administrative law or something else? I will try to understand it before everything. Maybe my presentation make more questions than answer for you. My study today is not about the relationship between these three. In the past, what happened in the past, this is not my job today. I want to talk about the relationship today, 21st century. Whether Fiqh rulings were successful or not in the past, I think somehow it was successful. But I'm talking about this issue today in the present time. I focus first on the meaning of so-called Islamic law, and you will find that this is a very confusing term. And second, on its possibility. This big question, on the one hand, is related to expectation of Sharia. What is our tawaqqu, expectation of Sharia? Do we have expectation, something like legislation, law, or more than this? And on the other hand, it's related to the function of different sections of fiqh in modern times. My answer to this question about possibility and impossibility are not the same in different branches of law. Some of them are possible, some of them, in my understanding, are impossible, which I will try to let you know. My point is that Sharia will continue meaningfully. From the beginning, I want to clarify that my understanding about Sharia is so positive. It will continue for Muslims and shape their lives. Fiqh will persist in rituals, quasi-rituals that I will explain what is quasi-rituals, civil rulings, especially family affairs, and theories of human interactions, قواعد المعاملات. I want to put a question mark in front of the possibility of other sections of fiqh. Most parts of fiqh ruling in mu'amalat, human interactions, such as criminal fiqh, al-fiqh al-jazai, or penal code, political fiqh, including Islamic constitutional law, and so on. My point is about impossibility of these branches of law, not the first one. And this is, I think, they are different. You will hear my argumentation for this. My discussion overall, legal schools and questions. and question both conservatives and reformists. It's not only analyzing critically the conservatives. You will hear some criticism about Muslim reformists too. So I'm between, and also somehow maybe more radical than some reformists, and sometimes I'm conservative in the objections, and you will hear this. It's not only about using the term of Islamic law. My point is not about the term. It's about the content. What do we mean by Islamic law? What is its relationship with fiqh? What is its relationship with Sharia? So my claim is restricted in time and domain. It means that about the time, I do not say anything about the past. The domain, as I mentioned, I will focus on some sections, some branches of fiqh, especially criminal law or somehow political law or something like this. I briefly introduce my understanding of Sharia, fiqh, and law, then argue the functionality of fiqh in worship sections and a few sections of human interactions, and finally argue the impossibility or dysfunctionality. My meaning is, when I mean impossibility, is not logical impossibility. I'm talking about, this is about the functionality of these three branches, or about three branches of fiqh. Regardless of calling them fiqh or Islamic law, I'm talking about the content. It's my problem is not only about Islamic law. I have some problems about fiqh in the modern time in these branches. About the past, okay, in other contexts, we can talk, was it okay or not? But in this context, it means that when we talk about Sharia or fiqh or Islamic law for today in 21st century, what is our talking? Okay, first part of my presentation is all Sharia. Sharia has two meanings in Islamic discourse. First, religion, ad-din, al-ain, it was translated to one of these two. These are the first meaning. And the second meaning of Sharia is creeds of prophets. So, in both of them, it was used in the Quran and also out of the Quran. But my focus will be on the second one, not on the first one. So the second meaning of Sharia, it means the practical teachings of religion, practical teachings of each religion. The first sense is general, as the second is a major part of religion, which includes akhlaq, ethics or morality, and fiqh. And most of the scholars, they forgot to use akhlaq here, ethics and morality. My discussion is concentrated on the second sense. It means creed of the prophets. According to the Quran, divine religion is only one. What is the name of this divine religion? It's Islam. But also Islam in the Quran has two meanings. The first meaning means submission to God. It does not mean religion of Prophet Muhammad. The second meaning is specific to him and his followers and his teachings. So when we use Islam in the first meaning, it means that Abraham was a Muslim, and awwalul Muslimin. And Noah was a Muslim, Moses was a Muslim, Jesus was a Muslim, and Islam was the common ground of all of these traditions. We will not talk about this meaning. The second meaning is different. The religion in God's eyes is Islam, devotion to Him alone. In Latin, in Allah al-Islam. Chapter 3, verse 19. This Islam means submission to God. It does not mean this religion. It means all Abrahamic religions, or all submission to God, devotion to God. Or وَمَنْ يَبْتَغِ غَيْرَ الْإِسْلَامِ دِينًا فَلَنْ يُقْبَلَ مِنْهُ وَهُوَ فِي الْآخِرَةِ مِنَ الْخَاسِرِينَ. if you seek any religion except Islam in submission to God, believing in the next life, this is harmful for you, especially in the next life. All prophets were Muslims. Islam is the common ground of all Abrahamic traditions. However, the Quran introduced 5 Sharia. This is the beginning of our understanding about Sharia. The Quran introduced 1 religion, 5 Sharia. What is this Sharia? 5 Sharia. Sharia of Noah, Sharia of Abraham, Sharia of Moses, Sharia of Jesus, Sharia of Muhammad. 5 Sharia. It means that these traditions are the same in believing in one God, believing in the next life, yes, and also supporting good doing, but they are different in Sharia. What does Sharia exactly mean? These are specified to each prophet. Who made Sharia? If Sharia is law or is ethics, who made this? So it was attributed to prophets, not to God. Sharia is not Shariatullah. It's Sharia of 5 of these 5. But religion belongs to God. We have divine religion. A part of it is Sharia. Also, Sharia is divine too. It was made by God or by the Prophet. But both Sharia and what is bigger than Sharia, that is religion, both of them are divine. Each prophet that comes abrogated the Sharia of previous prophet, partially or wholly, part of it or all of it. This is another thing according to understanding from the Quran. So, Sharia is different between these 5 traditions. The diversity of Sharia is because of different capacities of human being in different ages. So the human being in the time of Moses was different from the time of Jesus or from the time of Muhammad. So this is also from Islamic or Quranic understanding to the case. We have another term in the Quran that is close to Sharia. This is Millah. Millah, for Persian, it means nation. But here it means exactly Sharia. Millatu abikum Ibrahim. Huwa sammakumul muslimin min qabl. Millatu abikum Ibrahim. Millatu Ibrahim. He did not say Millatullah. Millatu Ibrahim means Sharia to Ibrahim. So Millah and Sharia are the same here too. In the religion of Islam, in its second meaning, not in the first meaning, means the Islam of Prophet Muhammad. The Sharia is one. Sharia is one. The Sharia of Muhammad. However, there are at least 8 different fiqh schools that are attributed to their founders. This is the beginning of difference between Sharia and fiqh. We have one fiqh, but at least we have one Sharia, but at least 8 fiqh. Which of them is correct? This is not something that in this world we can say, we cannot respond. In the next life, it will be appeared. So, these fiqh, different fiqhs, that each of them claim that we are presenting Sharia. If you ask them, say, this is Sharia. It means we have Ja'fari fiqh, we have Hanafi fiqh, we have Shafi'i, Maliki, Hanbali, Zaydi, Ismaili, and Ibadi fiqh. At least 8. We have Zahiri and the others, but they are the major one that we have it here. In the oldest Arabic translation of the Hebrew Torah and Christian Old Testament, Sharia was translated to Mosaic law or Christian law. When they wanted to use this, they said Mosaic law. It means this understanding was among the Jews and Christians, maybe under influence of Islam on that time. It was translation. The oldest one is translation 2nd to 4th century of Hijrah. Sharia has been used close to fiqh rulings in almost all Islamic sciences, in tafsir, in hadith, in falsafa, in irfan, Sufism, and so on. All of them use Sharia in this way, close to fiqh, not to akhlaq. Also in akhlaq, they use very close to law. These practical rulings were designated by God or His Prophet. The jurists derived from the Quran and Sunnah. Derivation means istinbat. So the source of fiqh is Sharia, is the Quran and Sunnah. That what the product of the fuqaha are something humanistic. The big difference between Sharia and fiqh is this. Sharia is divine, fiqh is human-made. We, the jurists, understood Sharia in this or that way. If we do not consider this difference, it made a lot of difficulty for us. The major question in this section, did the Quran and Sunnah use Sharia in the same meaning, synonym to fiqh? The Quran used 5 words from this root, 3 as nouns and 2 as verbs. I chose 2 of them. I will analyze briefly these 2 to understand from the beginning what did Quran say about Sharia. In chapter 5, verse 48, it said, فَحْكُمْ بَيْنَهُمْ بِمَا عَنْزَلَ اللَّهُ وَلَا تَتَّبِعْ أَهْوَاءَهُمْ أَمَّا جَاءَكَ مِنَ الْحَقِّ لِكُلٍّ جَعَلْنَا مِنْكُمْ شِرْعَةً وَمِنْهَاجًا. The last sentence is my point. لِكُلٍّ مِنْهُمْ. It means that so judge between them according to what God has sent down. Do not follow their whims, which deviate from the truth that has come for you. We have assigned a way, it was translated to law, Shari'a, and a path to each of you. Look at the translation, English translation of the Quran. Most of them, they translated Shari'a as law. My point is, Shari'a is bigger than law. Shari'a includes law, but much bigger than law. The second verse, ثُمَّ جَعَلْنَاكُمْ عَلَى شَرِيعَةٍ مِنَ الْأَمْرِ فَاتَّبِعْهَا. No, we have set you, Muhammad, on a clear religious path, so follow it. Religious path, religious way, because literally Sharia means path. So, godliness to be a Muslim is impossible without observing Sharia. To be a Muslim, we should observe Sharia. Sharia is essential for the unique divine religion and inseparable unit of scripture and the Prophet's tradition, Sunnah. Sharia in each tradition is one of its essentials, and it is the case of distinction of these traditions. But the difference between Christianity and Islam is in their Sharia, not in anything else. At least in what the Quran introduced Christianity. In the past, Sharia was tied to divine rulings or divine laws in the ancient discourse. In the other words, Mosaic Sharia means the ruling of retaliation. We have it in the Quran. And other Talmud laws, also the Quran mentioned them without the name of Talmud, but used the name of Torah. And Sharia of Muhammad includes the practical rulings in the Quran and Sunnah. Therefore, Sharia in the divine scripture is law-oriented. From the beginning, I said this. Why? Because some reformists said jurists made this meaning for Sharia. I wanted to tell you, no. According to the Quran, Sharia includes law. But the point is, does it include something else or only law? My point is this. And the jurists did not create this attitude in opposition to some Muslim reformists. Elaboration, the Quran clarifies that the divine rulings or legal commandments played an important role in Sharia. No, two questions arise. First, in addition to Sharia commandment or divine law, does Sharia have another element? Second question, are all these divine laws counted as constant and permanent, or is it possible to be among variables, temporaries, and abrogated? The second question is really a big question. My clear response could be this. Based on the holistic elaboration of the Quran and Sunnah, not a literal reading, Sharia has two components. The first is virtues, eternal moral values, and standards of Islamic lifestyle. And the second is practical Sharia ruling, including the rituals, ibadat, quasi-rituals. It means shibhul manasik. I mean by shibhul manasik, for those who did not read my articles about this subject, it means al-ma'kulat, wal-mashrubat, wal-mankuhat. It means Islamic restrictions on what we eat, what we drink, and in the time of sex. These are, as a Muslim, there are some restrictions on these three at least. Also, maybe we can find more. This is not ibadat, but I mentioned this is shibhul manasik. I will explain what's the difference between these two. This is the second, and human interactions, mu'amalat. By human interactions, mu'amalat, in fiqh, it means civil, commercial, criminal, and military rulings, or more than this. Okay. The first component of Sharia is the main and fundamental one, that is permanent and eternal, and it's not dependent on a specific time, place, or circumstance. It's forever. I mentioned this is Islamic lifestyle. Almost all rituals, quasi-rituals, and principles of human interactions are among the permanent Sharia rulings. But the most Sharia rulings in human interactions are not permanent, and they are time-bounded. I will present my evidence in this regard later. This was the first part, Sharia. Second part is about fiqh. Fiqh is the noblest Islamic science according to Islamic scholars. And Muslim scholars have written in this field more than in all fields through history. It's interesting that if you compare fiqh books with all Islamic books in other Islamic sciences, book of fiqh are more than all of the others. So this is importance of fiqh for Muslim scholars through the history. Its importance is justified in this way. Exploring divine law is the necessary condition for felicity in the next life, for Sa'adah. If you want to be happy in the next life, you should follow fiqh. Exploring fiqh, it has this function. The jurists derive, it means they made istinbat, derive the Sharia rulings from the Quran and the Sunnah based on a methodology called usul al-fiqh, or the theory of fiqh, or principles of fiqh. As the product of the jurist, are the products of the jurist divine rulings? Sharia was divine. Is the fiqh divine? I mentioned no. We should keep in our mind, this is big difference between this and that. So we can criticize fiqh because some part of it is wrong. But this is not the case for Muslim about Sharia. If you answer affirmatively, this means there is no difference between fiqh and Sharia. Those who said, are they the same? Okay, we have two terms for one reality. There are two approaches here in Usul al-Fiqh. It's very important for us. The first approach is called mukhatta'a. Mukhatta'a came from khata. Khata means error, mistake. And so these jurists taught that in the process of istinbat or derivation of fiqhi rulings, the jurist may make mistake. It means the product of him could be different, could be not correct. It's possible. The divine ruling is the real hukmullah. Hukmullah means God made it. It's real ruling. When we find the real ruling, next life, not here. It's impossible to learn what is real hukmullah, real God's ruling in this life. But the product of the jurists are hukmullah al-zahiri. So what does it mean? It means apparent hukmullah, not really hukmullah. But this is what they have done in their best to find the real hukmullah. This is the ultimate jurist effort for discovering hukmullah. Fiqhi products in non-essentials are presumptive, means dhanni, not qat'i. So it's because of it we have 8 different fiqhi schools. If it was qat', means something like essential, there is no difference. They are presumptive, it means dhanni, because of it we have different understanding. There is no way to obtain the real hukmullah in this world. It will be revealed on the final day. According to this approach, fiqhi rulings could be real, divine rulings, but no guarantee, and human mistakes are inevitable. In the case of Sharia, Sharia is fallible, but human understanding about Sharia that is called fiqh is not. It's fallible, not infallible. Fiqh is humanistic understanding of divine Sharia. Although the object of this understanding is divine rulings, this understanding means fiqh is not divine. Sharia is a perfect and flawless. However, flaws, imperfections, and errors in fiqh are probable. The jurist subjectivity, background, gender, social status, ethnicity, and personal desires may affect his derivations. But this is not the case of Sharia. This is the case of fiqh, the difference between these two. The other approach is musawwiba. What does musawwiba? Musawwiba came from sawab. Sawab means correct. It means it has 2 readings. The famous reading of musawwiba, taswib, is Ash'ari reading of this. They think that everything that jurists issue fatwas, they are correct. We do not find anything else. It means, according to them, also fiqh and Sharia are the same. But a lot of relativity is here. Their epistemology is relative, completely different from that one. There is neither reality behind this derivation nor any evidence for the existence of real hukmullah. Sharia and fiqh coincide. In other words, the production of jurists are called Sharia in the second approach. When different jurists from different legal schools issue different rulings, such as obligatory or prohibited, on the same subject, all are correct based on musawwiba. And some could be wrong based on mukhatta'a. Musawwiba's approach faces many unanswerable questions. Although Sharia is divine, ideal, and immutable, fiqh rulings can be changed by observing standards to reduce flaws and move toward perfection. What are the standards of Sharia? All Sharia rulings were just, reasonable, moral, and efficient in the time of revelation and in the time of presence of the Prophet. It's a big claim, but as a human being, if none of them were violated, why should we accept this ruling as ruling of God? These four standards should be observed not only in the time of primary legislation, but also in the time of continuity, today too. Not only the time of Prophet, but also today. It means that these are the permanent conditions of validity and probativity of Sharia rulings, hujjiyah. If they should be valid, they should meet these four criteria. There is no evidence to observe and implement unjust, unreasonable, immoral, and deficient rulings. If a ruling had these criteria in the past, but no, according to the knowledgeable mujtahids, it has lost all or some of them. It means that this ruling was previously Sharia, but it is not Sharia. It was Sharia, but it is not Sharia. Because no, something happened. It was just, today it's not just. It was reasonable, today it's not reasonable. It was moral, today it's not moral. It's a sign of rational abrogation. I discussed it in detail elsewhere. Sharia rulings are three types. Ta'abbudiyat, it means that simple command to be carried out without any rationalization except devotionality to God. The major point of ta'abbudiyat or worship is something you want to be devotion to God, nothing else. There is no rationality except this behind ta'abbudiyat. Second type, it covers worship such as prayer, fasting, pilgrimage, and charity. The second type is tawqifiyat. What does it mean? Beyond rational. Depends only on God's command. Does not require devotional intention. The difference between ta'abbudiyat and tawqifiyat is this. In ta'abbudiyat, you need qasdul qurbah. It means intention to be close to God. But in tawqifiyat, you do not need this. In the time of drinking, if you do not have this intention to be closer to God, your drinking is okay. But in the time of prayer or fasting, no. That intention was essential to that. So because of it, these are two types. They are not the same. But they have a common ground. Both of them are beyond rationality. When I say beyond rationality, I do not say anti-rationality. They are not anti-rationality. Anything anti-rationality is not acceptable in the corpus of Islam and Sharia. But we have something beyond rationality. Beyond rationality, for example, in Sufism is beyond rationality. Art is beyond rationality. You cannot rationalize faith. You cannot rationalize love. You cannot rationalize worship. You cannot rationalize also this tawqifiyat. This is a very important point for my conclusion. And it covers quasi-rituals, as I explained it, drinking, eating, and sex. Other rulings that are neither ta'abbudi nor tawqifi, it covers all mu'amalat ruling, all human interactions. So, in human interaction, what's the role of human reason? Can we understand it or not? This is the big question here. In the case of ta'abbudi, I say, okay, it's beyond rationality. In the case of tawqifiyat, the second type, it's beyond rationality. How about human interactions? Can we understand as a human something or not? In such rulings, mu'amalat, the jurist can understand something, but it's not correct to say the jurist can understand anything at all. We have two approaches. Many conservative jurists say there is no difference between ta'abbudiyat and mu'amalat. It means in both of them, you should follow the text. There is no ground, no room for reason, for human rationality. My point here is it's not correct. In the case of mu'amalat, human interaction, we can understand something. But when you say we cannot understand anything, okay, prove yourself, prove your claim. There are two concerns here. First, changing the Sharia rulings that does not have a Quranic root is somehow tolerable. But any change, especially abrogation of Sharia rulings which are supported by the Quranic verses, needs clarification. This is for conservative. We should solve this problem. When the source of a ruling, fiqh ruling, is in hadith, it's okay. Okay, you change it, it's okay. But when something is supported by some verses of the Quran is divine. The Quran is divine. How can you want to change it, especially in the case of mu'amalat? There is no collaboration, mulazama, between word of God and permanent or unchangeable ruling. God's command could be temporal, local, time-bounded, as well as universal, permanent, immutable, timeless, and constant. Those who think that all God's commands should be permanent, what is their argument for this? The best evidence of the occurrence of the former temporality or abrogation of God's command is previous Sharia. According to the Quran, most parts of previous Sharia were abrogated. Weren't they God's command? Yes, they were. It means that God may command temporally, not permanently. Is it only for those religions? No, it could happen for Islam too. Some verses that is related to the story of Prophet, history of the Prophet, it's only for his time. It's not forever. We can learn something from it, but this is not something that we can do it. The whole or partial abrogation of those Sharia is the consensus of all legal schools without any difference. Consensus. Okay, it means you accept the possibility of this. Why you do not agree here? There is no difference between them. It means that temporal God's command and their abrogation are possible and happened. Possible and happened. I'm not talking about the abrogation of the verses of the Quran, abrogation in reading, naskhul talawa. No, not ever. I'm talking about the possibility of change and abrogation, naskhul hukm. Also something that is called fiqh, not about Sharia. Of a few Sharia rulings, these few Sharia rulings is about 20 verses of the Quran, not about 500, because these 500 ayatul ahkam, most of it is about worships. Less than 50 of them is about mu'amalat. Among these 50, we have problems with about 20. I can tell you word by word which verses I'm talking about. Second concern, it was the first concern, so I try to solve it. The second concern, distinguishing temporal from constant and abrogation, is not restricted to only narrative evidence, like sam'iyat, naqliyat. We can rely on rational evidence, aqliyat. This is the big difference among the Muslim jurists. That what is the capacity of human reason in derivation, in istinbat? Independent rational correlations means ملازمات عقلیه مستقل is accepted by Sunni Mu'tazilite Muslims and Shiites, Usuli Shiites. But almost all other Sunni scholars and Akhbari Shiites did not accept this capacity for human understanding, human rationality. So what I will say is not acceptable for the second school. It's based on the first understanding. That means that our reason has this capacity to understand. For example, cutting the hands of the thief is not okay today. Also, it was in the scripture. I'm talking about this. So something like this, or for example, when we say inequality of the gender inequality, gender discrimination, if we have something like this, it's not acceptable. Or when we have something about religious discrimination, we should do something about it in the modern time. I'm talking about these issues. So those conservatives should tell us, are they efficient? Are they moral? Are they just or not? Although reason, aql, is one of four sources of fiqh in Usuli Shiite, unanimously, in theory, the mainstream in practice has not observed the right of reason and had often conservatively relied on narrative evidence. It means in practice, few of them rarely rely on this capacity of reason, aql. Also, in theory, they supported it. The rulings in the Quran and Sunnah are conditional to these four standards that I mentioned: reasonability, morality, justice, and efficiency. I think also it was not mentioned in the text, but rationally, they are conditional to these four. My point is that Islam never ever called anyone to accept unreasonable, unjust, immoral, and deficient compared with more efficient rulings in the other legal systems. Some fiqh rulings have gradually lost some or all of these essential standards over time. Understanding of human being about gender equality is different. About slavery, different. By 18th century, Aristotle and Plato supported slavery. But today, human rationality does not agree with this. The same thing happened 2 centuries ago. We did not have this understanding about gender equality that we have today, Muslim and non-Muslims. We have John Stuart Mill. He was not a Muslim. Go and read what he wrote about this. So this is something which I want to say. Rationality of human being has changed. Rationality of human being, the criteria has been changed. I can tell you in many issues like slavery, like gender equality, like religious equality, and so on. Many points we have changed. Humanity, it's not about Islam. We should consider these points, and after that, returning to ourselves. I'm telling that we should understand these verses or these rulings according to the rationality of our time, because this school accepted rationality. When it accepted rationality of the time, not rationality of 14 centuries ago. Rationality of 14 centuries ago is not valid, is not sacred, that we should obey it. So, my point is about fiqh rulings, which include one or all of these features. 6 points. Very clearly, I can tell you, if you do not accept these 6 or do not consider these 6, our understanding will be problematic. First, legal inequality between Muslims and non-Muslims. about 2-3 pages, I gave examples, fiqh examples for this. Second, legal inequality between males and females, meaning gender discrimination. Third, legal inequality between slaves and free human beings, the problem of slavery. Fourth, legal inequality between jurists and commoners in public affairs, problem of guardianship of jurists. Fifth, freedom of belief and religion in the punishment for apostasy and blasphemy. Criminalization of apostasy is something happened in the history of Islam. Never ever, the Quran did not say this, did not criminalize it. Prophet Muhammad did not criminalize it. This is my point. But it was criminalized in fiqh. What happened? Should we follow it? Is it divine? Sixth one, arbitrary punishment, harsh punishments, and torture in the name of religion, in the name of Islam. I want to condemn it. These are against the standards of Islam. If any faqih, if any jurist issues some fatwa following one of these 6, we should condemn it. This is my point. According to Islam, according to Sharia, divine Sharia. Considering these 6, we can conclude that there is a big problem in juristic derivation, istinbat, and fiqh needs a structural reform. I call it a structural ijtihad. I do not want to explain it here today. I wrote it elsewhere. Okay, and the third part, Islamic law. What do we mean by law among Muslims throughout history? It's not Sharia or fiqh rulings. We are talking about qanun. When I used Islamic law, I used not ahkam Allah, not ahkam al-Sharia. I intend qanun, which has had an changing meaning through the history. I briefly discuss in 3 periods. Pre-colonial period until around the 18th century, the colonial period 18th to mid-20th century, and the post-colonial period since the mid-20th century. The first period, the longest one, was about 11 centuries. Since the Umayyad dynasty, I do not want to say something before that. There is something, but I start with Umayyad dynasty. What they have done in the case of fiqh, or in the all of them came from the Quran and Sunnah, especially in the penal code, or tax law, kharaj. Briefly, I can say both of these issues, they were in the hand of the Sultan, King, Malik, and his local governors. And under Ottoman sultans, Qanun expanded to administrative, military, and financial law in addition to penal and tax law. So, especially in the time of Ottomans, we have very understandable Qanun. Exactly, they use Qanun, and from the Mehmed II, we have Qanun Name. And this Qanun Name is somehow secular law. It's not derived from the Quran or Sunnah, but also they do not violate Sharia too. We understand if we want to manage a country, we need something law. This is not in the Quran, this is not in the Sunnah. I want to say administrative law is not a part of Sharia. It's not among our expectation of Islam and Sharia. From the beginning, the sultans, the kings understood this point. They made something in the name of Qanun or other names. We have in some countries, they call it Nizam, some call it they made Farman, they Qanun or something else. All of them are secular law. So we have Sharia, we have Qanun, parallel to each other. Some parts of fiqh were written as justification for what the rulers done without any sources in Quran and Hadith. I had some elaboration in the case of apostasy. In another university, I will express this. So this, what we have in the name of apostasy and blasphemy, criminalization, is not from God or his prophet. It's by the rulers. And some faqih, some jurists can justify it, fabricated some hadith that prophet said this. Never ever prophet said that. Also it's in Sahih. But I want to say, my point is, it was fabricated. They changed something in fiqh. And so very ugly Sharia, I want to say we should differentiate between these. Or we have another thing. If you read Mawardi, Ahkam al-Sultaniyya, you can understand what does Amir bil-Istila, or Al-Amru bil-Ghalaba, means by force. How can you justify it through the Quran or Sunnah? Almost all of the rulers in the name of Islam came to power in this way. By force. Not by agreement of the people. Not by shura. Not by bay'ah. Bay'ah by force. We are talking about such an issue. The first Qanunnameh I mentioned in the time of Mehmed II in 9th Hijri, 15 AD century, and there was a secular law. It came from Urf and Ada, not from the Quran and Hadith. The European power colonized more than 90% of Muslim lands in 18th, 19th century. 3 countries we have today were not colonized, but also they were under influence of these powers on that time. These powers not only colonized the politics and economics, but also colonized Sharia. Interesting, colonized fiqh. They made Islamic law. For the first time, it was used that British Mohammedan law. Okay, the combination between British law and they call it Sharia or fiqh. Anglo-Mohammedan law. Exactly, they use this name in India. And France and Dutch and the others made their laws here. And it's interesting that they chose only this part from fiqh, civil part, family affairs, nothing else. It means since the colonial time, in Muslim lands, 90% of them, there is nothing remained except this part of fiqh. All the other parts were removed. In the post-colonial time, what do we have? Also, they are independent in politics, but in economics, they are dependent. And they followed in this way. It means in Egypt, in Syria, in Iraq, in all of these countries, you can find the same understanding of law. For them, law is civil law, nothing else. When they used in the other part of law, they followed European law. Those countries that were not colonized. One of them was Saudi Arabia, the other one was Iran and Afghanistan. So we have Islamic State in these countries today. And it's interesting that when Saudi Arabia does not have any constitution at all, this is creed of the Malik Sultan. We cannot find anything there. But in the case of Afghanistan under Taliban, I read their books, and I'm talking about impossibility of such a legislation today. If you do not read it, please read it. This is very interesting, 2022. It was introduced by the leader of Taliban, Haybatullah Akhundzadeh. And what we have in the name of penal code in Iran, Qanun Mujazat Islami, Islamic Penal Code in 2013. So when I'm talking about Islamic law, I mean these two. what Taliban wrote, I read, what we have in the name of Islamic law in Iran today, especially penal code. I read from the beginning to the end, and what is their understanding about this? What is called Islamic law in these three countries are different. Also, one is Wahhabism, the other one is Shiite, Iran, the third one is Hanafi fiqh. But I wrote that the understanding of Taliban, understanding of Iranian governments are different from mainstream of Hanafis and Shiites. They are in minority in their schools, both. I do not want to say all Hanafi Muslims that are a majority. 40% of Muslims are Hanafi today. Most of them do not agree with Taliban. Many Shiite, I'm also said, more than 90% of the Shiites disagree with this understanding of Shiite fiqh, what we have in the name of Islamic Republic today. So comparing Islamic law since mid-20th century in all Muslim countries with their diversities, with fiqh rulings, we have highlighted several concerns. Very briefly, I mentioned them. First, when I say fiqh is different from Islamic law, please pay attention to these points. The first point, there was pluralism in fiqh. Islamic fiqh is plural. We have 8 schools of law. Each school has different approaches in them. But when you want to codify law, you can follow one school and one jurist. It means you remove this plurality. It's impossible when you're writing law, qanun, it's impossible to have all of these pluralities. This is number one. Number two, when in fiqh, we have 5 different hukmullah, it's rulings. This is obligatory, this is prohibited, this is recommended, this is makruh, and this is neutral, permissible. But when you want to write qanun or law, it's only prohibited or obligated. 3 of them were removed from another side, that they are good because you are permitted to do this, or something that it's recommended and so on. This is the second one. And the third point, who is the major player in the state law? Government. Fiqh was not made by any government. They tried to make influence, but it was not made by governments. So when you write law, you use Islamic law, it means it will be under power of the state. It's a big problem for fiqh. Governmental fiqh, destroying fiqh and religion, both. If I want to explain it, it takes time. And the other one is fiqh is acceptable. It means accepted both practitioners and non-practitioners. It means also we have some obligatory and some prohibited, but if you do not do it, you do not prohibit it, what happened to you? Okay, it's a sin, you will be in the divine court next life. But in the case of law, there's a police, there's a court, there is something that crime. I want to say religious sin is different from state crime. And when you make equality between these two, a lot of problems happen. So the 5th point is, when we say law, law is made by the parliament, Congress, the House of Representatives. But fiqh was made by the jurists. And those who made law can change it, can cancel it, can modify it. How about fiqh? Is it possible when it's based on fiqh, is name of Islamic law, is it possible to abrogate it, to change it? I made one example. لایحه of قصاص in Iran. So on that time, we have a crisis. They want to change something. So, oh, you want to change divine Sharia. Retaliation bill. Retaliation bill is the longest story. So there is big difference between Islamic law and ruling fiqh, ruling ahkam al-Sharia. I want to say that law was appropriate for example, tribal time or feudal time. Does they work in the time of industrial or modern era? Practically no. So there is big difference between law and ethics. Ethics could be permanent. But law, no, could not be permanent. Law is temporal, conditional. So my last point is this. I want to talk in concrete way. What do we mean by Islamic law in different countries? I give you two examples, one from Egypt, the other one from Iran. In Egypt's case, there is a very famous scholar in the name of Abdul Razzaq al-Sanhuri. He wrote Egyptian civil law. It worked by today, 1940, 1950s. His name is Al-Wasit fi Sharh al-Qanun al-Madani al-Jadid. It's detailed in commentary of the civil law, the new civil law. And it is from Sunni side. From Shiite side, we have something in the name of, it was written by Sayyid Hassan Imami before revolution, in the name of Qanun Madani, civil law. In 6 volumes. The first one was in 10 volumes, the second in 6 volumes. Both of them work by today. Those who want to talk about Islamic law, in the case of civil law, I refer them to these 2 books. It means they work today, also by some revisions. In the case of family law, there are many revisions happened by Iranians and others, Egyptian and so on. And we need more revisions. But I think this is possible. But it's interesting, none of them call their books Islamic civil law. Both of them call it civil law, Qanun Madani. Why? This is a question we can ask ourselves, but the content is Islamic. Civil law, including family law, is a branch of law that works in different Muslim majority countries. But in the case of Islamic commercial law, most of it are reasonable. So many scholars, many lawyers wrote that we can accept commercial Islamic law too, by some modification, by something that we have new. So in the case of commercial law, I think I counted is among possible branches of law for today. But in the case of 3 branches of law, this is my different points. First is about, it's a different, criminal law. Second, political law, including constitutional law. Different name in French and British approach for the name. And international law includes war of the law of the war and peace and so on. We have rich Islamic ethics. We have rich Islamic ethics. In these 3 cases, I mentioned some sources for it, but because of the time, I do not read them. But if we want to have law, criminal law, as a scholar of this field, I reached this point that I cannot reform them. They are essentially problematic, fundamentally problematic. It means that we need something new in the name of criminal law, in the name of political law, in the name of international law. They are not something like civil or commercial law. So my point here is please read what Taliban wrote, what Saudi Arabia governments do, what Iranian governments do in this case. I wrote about all of them. I prefer arranging law using human experience and Islamic ethics without label of Islamic. We do not need to Islamization of law. It was started in Iran and some other countries, and this is, I think, the dream of many fundamentalists, and this is not a correct dream. They have misunderstanding about Sharia. Concluding remarks for and the end. Sharia as a standard of Islam and the Islamic style of life can and will continue strongly. First point. Second, fiqh will and should continue in the field of worship and rituals, quasi-rituals, the principle of human interactions, and many parts of civil fiqh, including fiqh of family, fiqhul usra in Arabic, they call it, with observing gender equality and religious equality. Third point, Islamic law may be used in civil law and commercial law by observing 4 criteria: reasonability, justice, morality, and functionality. The last point, other branches of law, means criminal law, political law, and international law, are counted as impossible. Deficiency. The cost of Islamizing them is much greater than leaving them to secular law while respecting Islamic ethics in these areas. Assalamu alaikum wa rahmatullah. Thanks for your listening.